All right, let's go on the record on cause number DC 1917340, Fisher v. Fisher. Council, make your appearances.
Morgan Scott for Gail Fisher, Your Honor.
Seymour Roberts Jr. for Clifford Fisher and Company and Clifford Fisher.
Alan Lowenson for Ted Uzelak and Larry Teal.
Heath Kaufman and Reed Loftus for Jed Thomas Smith.
Okay, so we have a number of hearings today. What do you guys want to start with?
Go ahead, Seymour.
Judge, I think the Rule 91A motion has been taken care of. We've withdrawn the matters that were complained about.
Okay.
So that's taken care of. I think really the only thing that is left, Judge, is a status conference on trying to set three pleadings. We have three.
Set what pleadings? You said three pleadings?
We have three enforcement pleadings: a motion for a receiver, a motion for contempt, and a motion for a court of inquiry. When we asked Ms. Pinson to set them, Mr. Godwin and I estimated that it would take over an hour to hear that. It might take as much as 4 hours to hear that. And Ms. Pinson said, well, you'll need to get more time. You could do it on a Wednesday, a Friday, or a Monday. And Mr. Godwin and I thought it would make the most sense to set it on a Friday and the following Monday so that there would be no interruption. And so Ms. Pinson said, before we can set that, you need to check with the judge. So that's why we're here. We want permission to go over an hour. I honestly don't think it'll take I don't think it'll take 4 hours, but with the way some of these hearings go, they can be long sometimes. And as you know, Judge, I can't say hello in less than 5 minutes. So Mr. Godwin isn't here, but Ms. Scott and I are here to see if we can set it on a Friday and a Monday and get at most 4 hours, but we probably won't need that much time.
I don't really want to do it on a Friday and a Monday. But I could probably set it on a, let me see. Probably just want to set it on one day and do it on like a Thursday. I guess, do we really need that much time for this? I've read that stuff. I don't think it's going to take that much time unless is there some kind of evidentiary hearing we're going to need?
Well, we're going to want to submit evidence. I don't think it will take 4 hours, but Judge, I hate to be in a position where I underestimate as opposed to overestimate.
Yeah, I would suggest we just do an hour and do it on a Friday. I can't imagine this is going to take that long. You said the court of inquiry motion, the receivership motion. What was the other motion?
Contempt motion.
Contempt can take longer. And remind me, what's the contempt for again?
Well, they all deal with the fact that before the divorce court entered the decree of divorce, Gail took $5 million out of a company account in violation of a standing order, and then spent $1.75 million of it on a new residence in violation of three separate TROs.
In family court. TROs that were issued in family court or my court?
They were all issued in the family court.
And why are we hearing it here?
Because the family court sent it to you, Judge. We wanted to hear it in the family court, but when the court heard that the mandamus was issued, the court sent those matters to you.
And we had a tribunal hearing in the divorce court to determine what court, the 68th or 254, would hear these motions. And of the 11 or 9 motions that were pending to determine what court would hear what, the 254 kicked those contempt motions back to Your Honor's court.
Okay. I just don't understand why I would hear a contempt motion on an order issued by another judge.
That was our feeling, Judge, but you know, we don't sit on the bench.
I hate to make you play ping pong, but I mean, was it an order, a TRO that was issued as part of the divorce decree, or was it one of these ones that was more of a business?
These are injunctive relief orders dealing with the fact that the matter was going to go up on appeal. And so the court was telling the parties, you know, don't do anything until these matters are heard on appeal. And what happened was there were 3 injunctive relief orders entered, a first, a second, and then a third. And they had numerous provisions, but the provisions that we're relying on deal with the fact that they say that you can't spend money from a company account. And I represent the company. And Gail took money out of a company account in violation of the standing order. And then she spent 1.75 million of it on a new residence. We say that taking the money out of the company account was a violation of the standing order, and spending it was a violation of the 3 injunctive relief orders. We filed these pleadings in the family court. We, as Morgan Scott accurately stated, we had a hearing in front of her where we said, Judge, we think these matters need to be heard in your court. And Judge Brown, you remember that Judge Wysocki is not in that court anymore. Judge Brown said, no, these matters have to go in front of Judge Hoffman because of what the Court of Appeals ruled in the mandamus action.
I will add, go ahead, Seymour.
Judge, we just want to have these heard. At this point, with all due respect, I don't care so much where they're heard. I just want them to be heard.
Ms. Scott?
Yeah, thanks, Honor. And I will say that the mandamus order that came out said that these matters were anything not related to the enforcement of the divorce decree would be sent back to the 68th. So the 254 determined that the contempt relating to 5 million was not enforcement of the divorce decree. So in that regard, it was sent back to 68 because it wasn't a part of the divorce issue. So that's how she ruled it on.
But wouldn't a violation of the standing order isn't the standing order something that's for all family law cases? Is that the standing order you're talking about?
Yes. Yes, Judge. And we made the argument that enforcement under Chapter 9 of the Family Code means that the matter could stay in her court, but she didn't see it that way. You know, we made that argument. Judge, if you want to take this under advisement and then, tell us what to do, that's fine. I know we're springing this on you at the last moment. You may not have had a chance.
No, it's fine. It's just, it's a little puzzling to me why I would be trying to enforce another judge's order. But I guess I should also look at whether or not the order should have been entered at all, I mean, but I don't know, maybe not. Let's see.
And to Mr. Roberts' point, we do have some possible dates already that we have gone back and forth with to determine, it could be heard in your court if it wants to go on just a Friday. We do have some agreement on a date.
What dates do you want to propose?
Sure.
November 5th.
That's a Friday.
Yes.
November 5th. I can't do November 5th. What else do you have?
Well, we have November 8th. That's a Monday.
I can't do November 8th.
And then I'm out 2 weeks.
What else do you have?
We haven't gone that after that. Ms. Scott and I will have to confer.
Correct.
Do you want to do December 3rd?
So far, that works for on my end, Your Honor. I would need to obviously confirm with Mr. Godwin and Ms. Fisher, but I can do that today.
And the same goes for me, Judge. I mean, my calendar is fine on December 3rd, but I'll have to check with the co-counsel and my client.
I could do December 3rd, 10th, or 17th.
Okay.
When is the trial setting on this case?
So that's the other matter we're here on, Your Honor. There's also a status conference to talk about the trial date, because right now the docket does say June 29th. And when we had spoke, I believe sometime earlier this year, we were all in agreement to move that to a spring 22 trial date. And then there were some issues with doing an agreed scheduling order. So we're also on that matter as well. But when you're ready to talk about it, we can get into that.
Do we need to hear these three motions before the trial setting? I would think we would.
Yes,
Yeah.
Judge.
I mean, one option would be we could hear these motions on the 3rd and do the trial on the 7th, September 7th.
And do trial on December 7th. Let me see. I don't know if that will work, and I don't want to speak for Mr. Kaufman, but I think he might be chiming in. He was just added as a defendant, and when we spoke maybe a month ago, we counsel for Mr. Robertson, Mr. Lowenson, and I, we had an April 22 trial date that was tentatively agreed on, and then when Judge Thomas was added, he had Mr. Kaufman spoke to me, and he did not believe an April 22 trial date would work. So he was maybe going to propose a later date, and we're agreeable to that to the extent it's not too far out. But I'll let Mr. Kaufman speak if he wants to.
Yeah. Your Honor, she accurately reflected my position on that. I just think we were just added last month to the lawsuit, so we're a little bit behind schedule.
What is Mr. Kaufman's role here? What did he allegedly do?
Sure. Oh, go ahead.
Yeah, Your Honor, can you hear me okay?
Yeah.
Okay. I represent Judd Thomas. It's a CPA firm that represented both the Fishers and their company, and we were brought into the lawsuit by Ms. Fisher related some, basically, I'll let Ms. Scott kind of outline the allegations, but it's essentially a malpractice claim that's been brought against my clients. And we were in federal court, that got dismissed, and then we were added to the state court lawsuit.
That's correct, Your Honor. Yep.
What discovery needs to be done related to Mr. Kaufman's client?
So with regards to accounting malpractice or any type of alleged negligence or conspiracy done with that accounting firm and with Mr. Fisher as well. So we would need to just look at all their records with regards to the way the company is structured. It's an S corporation status. So with regards to distributions, which is one of the big claims we're claiming, we would need to see how they looked at distributions and commissions for the company to pay for Gale.
And Judge, when Ms. Scott and Mr. Godwin added Judd Thomas, they added 3 new claims, and 2 of those claims, I believe, involved Mr. Fisher. So we are going to have to take more discovery now because they've added more claims against my client. I've asked Ms. Scott and Mr. Godwin to allow me to send them additional written discovery on these new claims. They said they would object, so you can expect that I'll be filing a motion to increase my written discovery and to increase the time to take Gail Fisher's deposition.
Your Honor, I might add that my clients haven't taken any discovery. When we were in federal court, it was on a motion. We were basically stayed waiting for a ruling on a motion to dismiss for lack of subject matter jurisdiction. So we didn't get anywhere in that case. So we really are starting as if we started in April, and we need to serve discovery. And it's a professional liability case, so we're going to have to both sides are going to have to designate experts as well and find experts. And
Does it make
review
sense
things.
to even have these claims with the rest of the claims? Are they so interwoven that we need to try all these together?
Well, that's a good point, Your Honor, and that's something I'm looking into. I think really we could be separated out from this lawsuit, and I think it would be more efficient. I haven't finished studying the procedural rules on how to do that, but it overlaps for sure with the Fisher claims, but our issues are, at least in terms of my client, they're much more discreet and focused than everything that's going on in this Fisher lawsuit, which is a lot.
I would say that they are interrelated, Your Honor, because it is with regards to distributions and how an S corp is structured. When you have to pay distributions, the timing and the method of them, and we're alleging Gail was not paid these distributions, and so to the extent Judd Thomas knew how they were paid or how they did the accounting for the company, it's involved with all the other claims we're making.
Okay. There's no question we need to move this in the June 29th setting. I'm just trying to figure out how far do we need to move it. And my concern is that I've seen cases like this, is the longer they last, the more that they kind of expand. And so I'm concerned now that we have a new party. One option would be we sever out the claims against these malpractice claims that seem to really kind of muddy the waters to me, and then try this in September and try to just get this thing done. Mr. Roberts, what do you think of that?
Well, Judge, if my client will not be here in September, so that's going to be a problem for him.
Where is he going to be?
I don't know, but he has made plans not to be here in September and has instructed me that, I wanted to set the enforcement pleadings much earlier. My instructions were, Seymour, don't do that. So that's why we set him in November. I couldn't even get him in October. So I don't know where he's going to be, but I know that he will not be in town. I mean, he'll be out of the country, I think. And assuming we don't add, assuming we sever out the Judd Thomas matter and we take away those new causes of action against my client, that's one thing. If any new claims are going to be in this case against my client, I'm going to want to take more discovery on them. And I don't know about a September trial setting. I would think it would have to be a little bit later than that.
And I would also add, Your Honor, we had an MSJ, or Seymour Roberts and Mr. Lowenson had an MSJ based on res judicata that it was ongoing for 3, 4, 5 months. And during that entire time period, discovery was halted. We could not do discovery.
You saw I ruled on those, right?
Correct.
Yes.
Yes, Your Honor. So that just came out June 4th. So given that the order came out June 4th, we do have agreed orders with Your Honor that do say now within 30, 60, or 45 days of that ruling, depositions can begin and discovery can begin. And Your Honor had previously granted us the 16 depositions to do based on an order. And so all that would need to be done. And so I'll be honest, the September will not work for us.
Okay.
And before we get to that, I believe that we did file a motion to reconsider the scheduling order, which will also have to be heard.
And that was supposed to be heard on the MSJ date, Your Honor, but it was moved. And that would have been, it was Mr. Roberts' reconsideration of the scheduling order that Your Honor entered in September of last year. But it was moved from that MSJ date. So that is still pending. And that's part of, we did have, counsel and I did have, we went back and forth for I'd say about a month trying to get an agreed scheduling order. We all agreed on an April 22 date, minus Mr. Kaufman. This was before he was added. But we could not agree on the language, the precise language to be used in that order. So that's kind of where we're at right now is while we have a trial date that could work, the language in the order could be an issue for us, but we can work on that.
So what was the date in April you wanted, I guess?
Yes, Your Honor. We have April 26 of 22.
Okay. I don't anticipate that would be a problem. April 26th. And then let me look at one thing. Okay. Let's just go ahead and set the those three motions on December 3rd. And we'll give you an hour and just kind of see how it goes.
Judge, do you want me to file a notice of hearing?
Notice of hearing for the three
The third?
motions. Yeah, that's fine. Can Eden, can you go grab Rhonda? So anyway, go ahead. We'll set that for December 3rd. Why don't we do that at 9 o'clock, and then we'll set this, you said, on everything else on April 26th. So they have three motions that they want to have heard. I want to give them a full hour. So December 3rd is when they want to hear it. Okay. And then they want to reset the trial setting. We set to what, April 26th?
Yes, Your Honor.
Okay.
Got it.
And you got the trial setting for April 26th? Mm-hmm. Okay. All right. Anything else we need to talk about?
Well, we need to enter into a scheduling order. I'm not really sure where that leaves us with that.
What's the area of disagreement?
So I believe, Your Honor, it was with regards to just some rebuttal designations. So I believe Mr. Lowenson, who has another counsel, I think it's Ms. Carrie Schoenwald, there was maybe some input regarding some rebuttal designations, and we had disagreed on the rebuttal designations as we believe they were too superfluous. So we wanted to keep the original language that was used in Your Honor's original order, and they wanted to add some additional language.
Your Honor, can you hear me? I apologize. I'm at the airport, so I apologize for the background noise. This is Alan Lowenson. Can you, Your Honor, hear me?
Yes.
And I apologize, video for whatever reason isn't working on my phone. I don't have the scheduling order in front of me, so let me just tell you what the issue was as opposed to the specific language. In every scheduling order I've been involved in, we have provided that if a party is going to use deposition designations from a witness as opposed to live, which, as you know, any party can do as a matter of right, there would be an initial date prior to trial for the designation, the initial designation. Then a couple of days would pass. There would be a date for the parties to make objections to that designation and then make cross designations. A couple of days would pass. There would be a deadline for objections to the cross designations. And then the party calling the witness, just as if they were called live, would have the right to rebuttal designations in response to the cross designations. And then there would be a deadline for any objections to the rebuttal designations, and those would be spaced out so that those would be completed prior to trial, so that Your Honor would then have the option of deciding to hear those objections prior to trial, or at least they would be teed up for when the witness is called. And I don't recall exactly what part of that they didn't agree to, the plaintiffs, but there was some disagreement on their part with respect to that plan. So that was the issue as we understood it.
And I will add, I'll add, Your Honor, the way the language was written by Mr. Lowenson or his counsel that also works with him, it was as if we were trying to exchange depot testimony or depot designations 3 times, and then we had to object 3 times. So, I mean, there was literally like a 6-step process, as opposed to just doing designating your direct deposition testimony, and then we can go from there. And that's the way that the original order was written, and it was pretty short and sweet to the point. And so we preferred to keep it that way. But obviously we had an issue with going back and forth. I think it was 6 times.
Your Honor, I don't think it's 6 times. I mean, by definition, if someone makes a direct designation, you have to know what that is before you decide what you're going to cross. And if someone's going to rebut the cross, they have to know what the cross is. So there has to be some time spaced to get those, to analyze them, and the same with objections. So it's not 6 times. It's a designation of direct. It's objections to that and cross. It's objections to the cross and rebuttal, and it's objection to the rebuttal. So I don't understand.
I don't have a strong opinion either way. I've seen it done both ways. Usually it's done the way it was just that Ms. Scott has said, where it's a designation and a cross, but I don't have a strong opinion either way. I don't think it's quite as complicated as Ms. Scott is saying, but it does. And I will say this: if there is going to be a lot of, or really anything more than just a very minimal amount of depositions that are going to be read or played at trial, and you need me to rule on objections, I need to have a pre-trial conference in advance of the day of trial, because I have had situations where people bring me a notebook with 8 depositions, and I'm supposed to rule on the objections on the day of trial, and then it's very hard for me to do that. So just kind of my bigger concern is not how you do it between these 2 methods, which I don't think are that different. It's I just need to have time to rule on it. So once you get closer to trial, make sure you request a pre-trial if you need one, so that I can rule on that. I think sometimes attorneys, I know I did this when I was in private practice, kind of thinks that the judge is like a computer and that you can just stick it in and get a ruling and get it back out. We need to have time at some point to go through these. So just kind of be aware of that. But if Mr. Lowenson, if you want to do it that way, I don't have necessarily a problem with that. And let's streamline it as much as you can. Maybe make the objections and the cross designations due on the same day, and then the rebuttal designations and the objection to the cross due on the same day.
Absolutely. And that's what if I didn't say that, I should have. I am intending they would be the same day. So basically there would only be 3 days of designations: the direct, the second day is objections to the direct and cross. Actually 4. The third day is objections to cross and any rebuttal. And then if somebody's got an objection to rebuttal, and oftentimes I find rebuttal isn't even played, but absolutely they would be due in each of those cases on the same day. There wouldn't be 7 different days.
Let me tell you how I prefer to have this submitted to me if it comes up is to give me a notebook that has all of the depositions in it with highlighting in the deposition. So anything that and the objections, you can either handwrite them, or they're now computer programs where you can put what the objection is. And then I prefer to have them played just because it's a lot quicker and easier, is have them played as just one deposition. So even though there's designation, cross designation, rebuttal designation. Just play it all as one deposition. You can do it in that order if you want. It doesn't have to be consecutive with how the deposition is done, but you know, I like to play it just as one deposition, not as, you know, 2 or 3 different.
Absolutely. That's the way I've done it too. So that's good to know. Thank you, Your Honor.
But make sure that all of the designations and all of you, it means you guys are going to have to work together to submit a notebook that has everything together in one. I don't want to have
Right. Duly notebook.
have three different versions of this that I have to rule. I need to rule on these quickly. So
What I've done, Your Honor, I'm sorry to interrupt. What I've done is just different colors for the two sides.
Yep. Exactly.
Okay. Well, I think we can work with council now and we'll get this scheduling order finalized and agreed to and submitted to Your Honor. Thank you.
All right, guys. Anything else?
That's it, Judge, for me. Thank you very much.
All right. Thank you, guys. Good luck.
Thank you.
Thank you.
Have a good day. Okay, let's let Mr. Lowenson leave. Let's chat about a quick scheduling issue. And I sent out some probably a little bit confusing text about this yesterday. I was at an event yesterday